Good morning, ladies and gentlemen. I would like to welcome you to this webinar. My name is Karim Bazabati. I'll be the organizer for this session, and with me is our presenter, Brad Burcha. Please make sure you have a stable internet connection, but don't worry, if you happen to get disconnected, you can log on the same way you did and everything will still be fine. There will also be a recording on the IOPSA YouTube channel and the plumbing app in case you've missed anything. I urge everyone to please fill in the survey, as that will just help us improve our services towards you. The duration of this session will be a maximum of 30 minutes, and we will answer questions towards the end of the session, ending off at 7:30. I would also like to thank our sponsors, PIRB and IOPSA, for making it possible to have these morning sessions. For now, I would like to hand over to our presenter, Brad. Brad, are you there?
Good morning, everyone. Thanks for attending today, and welcome back. I haven't been online for a few weeks, and I'm sure some of you have heard me talking before. Just a quick recap. My name is Brad Burcha, and I run a commercial risk consultancy business called Borcon, and we serve the contractual and commercial needs of all stakeholders in the construction industry. I am not an attorney, and my content does not constitute legal advice. It's my interpretation of the subject matter only. And when our IOPSA got hold of me to say, could we do a talk on the importance of having a contract, I thought that was a very relevant topic. Because frequently in my business, I have people coming to me generally to secure money that's owed to them, whether that's from retentions or unlawful contract charges or whatever. You know, it's always about money, and often I find that either they don't have a contract, the contract's not sufficient, or it hasn't been completed properly, and that lack of attention to detail at the start of a project is the one that gets most people into trouble. So today we will be having a quick look at the importance of having an express contract. Now, when I say express contract, I mean a contract that has been specifically drafted for two parties to sign, okay? So it's a contract that's been specially put together for your scope, whether you're building a house, doing some domestic plumbing work, working on a 300 million rand project, whatever it is, there's a specific contract, excuse me, between the parties. We call those express contracts. We'll have a look at what happens when we contract without such a contract, when we don't pay attention, when we sign it, and can these contracts bring other risks that you didn't know about? Okay, now bearing in mind how much time we have, I am going to shoot through these early slides, and apologies if you guys or some of the attendees have seen these before, but that doesn't matter, because the more you listen to it, the more I hope it will be ingrained into your thinking. So certainly, let's just get a frame of reference by looking at the structure of South African law and how it relates to construction. Since our conversion from a tricameral parliament to a constitutional democracy in the 90s, the constitutional republic of the Republic of South Africa has become the supreme governor of our law. So the attendees that are my age and over will remember that prior to 94, actually, yeah, it was around about 94, 96, we used to have a government that used to make all the laws themselves. That was the National Party in Parliament, and basically they could pass whatever law they wanted, whenever they wanted. They had the majority, and that was it. It's completely different now, because we have a constitution, and now it's not so easy. Okay, so the constitution is the supreme governor of our law, and all legislation, acts of parliament, these express contracts I talk about, any contract between two parties has to firstly comply with the provisions of the Constitution. Okay. The other thing you need to bear in mind is that our common law stems from the Roman Dutch system. So roughly speaking, that is the application or the interpretation of the old Roman law. It was interpreted and applied by the Dutch. So, clearly you don't want to be sitting in a position where you have to contract in the common law that was interpreted a few hundred years ago. And most of you won't have a clue what's going on in the Constitution. So why would you try a contract without an express contract? Now, the problem also is that there is no specific law of construction in South Africa. Okay. Individuals and juristic persons. A juristic person, of course, is a company or a trust or another legal entity that is empowered to contract. These people or entities are free to contract with each other on any terms and conditions they like, generally, no matter how onerous they are, provided the requirements for a valid contract exist and the prescripts of the Constitution are complied with. And that's why I brought that up. So two willing parties are able to enter into any express contract they like, as long as they abide by the Constitution. Okay, so you can contract right out of the common law generally. Okay, the requirements for a valid contract are easy to comprehend, which is why millions of contracts easily come into existence every day. You don't even realize it. Just going into a shop, okay, and buying something, you've entered into a contract with someone, but you didn't sign anything. Okay. Also, I just want to explain some further concepts because they're very important with relation to express contracts. The first is a Latin term called pacta sunt servanda. Okay, and what this means is that the courts will enforce contracts. Okay, so if you have an express contract that you've entered into with someone, it's a lawful contract. It's abided by the Constitution, and it's been properly entered into, which I'll get to in a minute. If something goes wrong in that contract, or if you claim you didn't read something in that contract, or you claim something to get out of that contract, the courts will be very hesitant to do that, okay? Because they'll be destroying the sanctity of contract. So beware. And the other term is caveat subscriptor, which literally translated means let the signer beware. And those two concepts go together. So when you sign an agreement, an express agreement, make sure that you've read it, because you cannot come later and say, I didn't see that small print. Okay, generally, there are some exclusions which are beyond the topic of this discussion, but generally, beware what you sign, make sure you read it, make sure you understand it, because once you sign it, the courts will enforce it if something goes wrong. Okay, to have a valid contract, this is what you need to have. You have to have an agreement of the parties for performance or non-performance. Very easy to comprehend. I would like you to come do some plumbing alterations on my project, and I'm going to pay you 100,000 Rand. Okay, so that's the performance. Okay, you must have capacity, which means you're of legal age, you're of sound mind. If you're representing a company, you have authority to enter into that contract on behalf of that company or juristic entity. There must be serious intention of the parties. Okay, it can't be a joke that both of you were inebriated on a Friday night and then you decided you're going to enter into this contract and Saturday morning you've forgotten all of that. Okay, that's not serious intention. You must have serious intention. Obligations must be possible to perform, but can be extremely difficult. So, to shed some light on this, if you're working on a building contract and you issued an invitation to tender, and it says this project will be completed in 6 months. You have a look at the drawings, you have a look at the spec, you have a look at the scope, and you realize to yourself, there's no ways this can be done in 6 months. Okay, best you don't sign it because you haven't reached agreement. Because if you do sign it, it doesn't matter how difficult it is, you need to do it. And if you don't, there will be consequences to that breach. Okay, so they can be extremely difficult. Okay, and you still have to do them. So beware. And that's quite a common thing in the construction industry, actually, you know, where developers, especially shopping center developers, are trying to get the price as low as possible, and the program as short as possible. And on top of that, they want the best quality. And those three things actually don't go together. There's a triangle of those three activities, and you can't have all three sitting in the same corner, even though they try their hardest to do that. Of course, the subject matter must be legal. Okay, you can't have a contract to market cocaine or some other illegal substance, so the subject matter must be legal. And formalities required by law should be observed, of which there are very few. Okay, you will see that contracts do not need to be in writing. They do not need to be signed. They do not need to go to a special office to get stamped. Okay, except in extreme circumstances like the transfer of property, etc. Otherwise, there's very few formalities that actually have to be followed. So that's all you have to do in order to conclude an express contract. And as I've said, it's extremely easy to do this. Okay, something may surprise you. As I've said, that very few contracts need to be in writing, and a contract comes into force when an offer is made and that offer is accepted by the other party. I did, sorry, in my slide here, I said we're going to spend some time on offer and acceptance, but I actually don't think we've got time to do that. So I'm just going to cover it here quickly. Okay. So when two willing parties of sound mind and a serious intention to contract decide to contract, one of them will make an offer, and the other one, once accepting that offer, that contract will immediately come in to force. Okay, so if you submit an offer, here's my tender for certain work that's described in my tender, and I would like to contract on the master builder's domestic subcontract agreement, or I'm going to use the new IOPSA contract for minor plumbing works. Here's my offer. Your client reads that offer and says, oh, I accept all of those terms and conditions, and I like your offer, please proceed. That contract is now locked in, and there's no going back. Okay, you can't the next day wake up. Generally, I mean, there's some stuff in the Consumer Protection Act, etc., also beyond the scope of this discussion, but generally, that contract is now completely in force. Okay, as I've said, that acceptance can be oral, so two people can have a serious discussion, decide that they're going to do something, and agree to it orally. They can put it in writing, which is obviously the preferred method, so that there's no dispute over the interpretation of that contract later, or they can do it tacitly, which means they may do it by conduct. Okay, so if you submit an offer to someone and they accept that offer by telling you to start, please start on site tomorrow morning. Contract's done. Okay, contract is in force. The reason we like contracts to be in writing is because if they are oral or tacit, and there's a disagreement over the terms, then you generally have to find a witness or someone else or something else, a circumstance to prove that that occurred. And why would you ever want to go through all of that? So all contracts certainly need to be in writing. Okay. I'm also not going to spend too much time on this, but it's also very relevant when talking about an express contract, and that is the term obligations. Okay, it is the foundation of contract. An obligation is something one of the parties has to do or dispose of in order to fulfill his side of the contract. Okay, so a contractor or a plumber has an obligation to build something. Your client has an obligation to pay, and often that is his only obligation. Okay? The contractor's obligations are extensive generally. I've listed some there. You know, you've got to comply with the quality spec. You've got massive safety obligations. You've got a time obligation in terms of program. You have to keep within budget. More often than not, you have some triple B, double E criteria you need to uphold, etc., etc. Your client generally only has one obligation to pay. Okay, you might have a few others like getting drawings approved or getting an NHBRC permit, etc. But he can actually pass all of those obligations onto you if that's what you agree in the contract. Okay, after that, a brief introduction to how express contracts work and why we need them. Well, sorry, a little bit more detail. What is an express contract? An express contract is one which is entered into by two willing and able parties who have capacity to contract and wish to contract out of the common law. It is important to contract out of the common law, which is hopelessly insufficient to support construction contracts. Okay, and as I've said, there is no specific branch of law in South Africa that covers construction, which I must tell you is quite different to other countries in the world, such as the UK, where they have a robust court structure that works with construction and specifically construction adjudication. Construction projects are peculiar for at least the following reasons. Okay, for those attendees who work on the larger projects as domestic subcontractors or nominated selected subcontractors, you have this animal known as a principal agent. Okay, as I've alluded to, time is normally critically important. You get paid on an interim basis, monthly, often in contract. You only pay once. So for example, if you buy a motor vehicle, you or your bank pays the supplier of the vehicle once. You don't pay the vehicle manufacturer in installments while they are constructing your vehicle. Okay, so construction is different from that point of view, and that of course brings risk to the payer. Okay, design is often undertaken by a third party. This is also a critical element that the common law does not support you with, and you need to have this express contract. So often you'll have you, the contractor, you've got a client, and a third party, an engineer or an architect or a wet services engineer or somebody is designing the work. Okay, and unfortunately, disagreements and disputes are common. Okay, so those are the reasons you really need to have an express contract. If you have a dispute and you do not have an express contract, your only recourse is the court. Okay, and as I'm sure many of you know, and I'm going to tell you again, the last place you want to go to resolve your disagreements is the court. Okay, it is way too expensive. It takes way too long. The system of appeals also expensive, and it takes too long. So unless you've got a multi-million rand dispute and you've got lots of cash flow to support the arguing of that dispute over a period of years, you generally don't want to go to court. Okay, so that is why you have to have an express contract. So it covers things like program, payments, design, and how to resolve disagreements. Okay, when you're entering into an express contract, you need to consider all of the above. You need to have strong and sufficient provisions relating to price and payment, as I've said, time, extension of time, your scope increases, your client adds more scope, okay, and you need more time to finish. How do you deal with that? Who provides insurances? Are you getting a payment guarantee? Are you providing a performance security? Is there a penalty if you're late? Or are there damages if you're late? There's a big difference. Also, not for today's content. Are the obligations properly spelled out? Do you have proper dispute resolution provisions? What happens if there's a breach? And many others. Okay. Having said all of that, which contract do you use if you followed my advice and have an express contract? Well, please don't attempt to create your own contract, okay? Unless you have a construction law background. Even attorneys will battle to put together a proper construction contract, and that is because they haven't really been trained in that, okay? Unless they decide, and there are, of course, attorneys who do that specialize in construction law and construction contract, for sure. But there are also documents that are called standard form agreements, okay, which have evolved over the years that have got bodies of constituents like the Association of Architects, QSs, project managers, engineers, the MBSA, etc., etc. They've all got together over the years and they've put together what's called a standard form contract, which is specifically designed for construction contracts. Okay. For example, there's the MBSA suite of contracts. Now, the master builders, they have a nominated selected contract for the bigger contracts. They have a domestic contract. They have a house building contract. They have a contract for alterations. They have a contract where there's no principal agent, etc. The JBCC certainly, sorry, let me correct myself. The nominated selected document issued by the JBCC and not the MBSA. Certainly for the bigger contracts where there's a principal agent. IOPSA is in the final stages of releasing their new contract. That is designed for the smaller plumbers who do alterations, additions, domestic work. There's no principal agent. Much simpler contract to comprehend, but it takes into account all of the items I have discussed previously. There are other contracts, GCC, which is the general conditions of contract, the NEC, the new engineering contract, FIDIC, and a few others. Okay, certainly beyond the scope of this discussion, complex agreements designed for big projects where people are experienced in using those contracts. The NEC, for example, is so complex that you actually have to appoint a contract administrator to run that project on your behalf. Okay, whatever you do, do not contract without an express agreement. You will land yourself in trouble. Okay, you go running to your attorney, or you come running to a claims consultant, or like myself, I'm in trouble. Please, this client hasn't paid me. They're trying to take damages off me. There's a dispute. You don't have a contract. I can't help you. Okay, no one will be able to help you. All you will do is spend a fortune on legal fees. So please, guys, do not contract without an express agreement. Okay, as I've alluded to, what happens if you contract without it? You're subject to the courts. There will be a major difference in opinion on the interpretation of your contract. Okay, there's a whole legal industry that survives because two lawyers interpret something different. Okay, so you will be exposed to damages as opposed to penalties. Okay, so damages is very quickly is a claim that the other party will throw on the table to say, you caused me all these damages due to your default in time or performance. This is what I want. A penalty is an amount you pay per day for being late. Okay. Of course, you could be exposed to irregular payments if your payment structure is not properly recorded. Okay. Once again, if you don't pay attention when signing your contract, if you leave things blank, if you don't fill in the boxes that you're supposed to fill in, you will similarly expose yourself to interpretation and the mercy of the courts. Okay? Two things you don't want. Of course, like everything, express contracts bring other risks. And they generally bring these risks from not paying attention to detail when you start. Okay? One of the biggest risks are time barring provisions. So you will see across all those contracts I spoke about a few minutes ago, they've all got what is known as a time barring provision, which means if an event or circumstance happens, you've got so many days to tell the other party about it. I notify you of a delay. I'm going to submit a claim for that delay. Okay, so if you're not on your toes, you forfeit your right to claim for time. There's similar provisions for cost. Okay, so yes, once you've signed that express contract, you need to manage it. You can't just throw it in the drawer. Okay, especially if you're on a complex project, things are changing all the time. You're getting new information all the time. Okay, you need to manage it. Okay, and of course, having a penalty, which is a much better thing to have, let me tell you, compared to a general damages clause. Because at least with a penalty, you know what your penalty is. So you know, if I'm going to be a week late, I'm going to pay, for example, 10,000 Rand a day. Okay. Of course, the risk of having those things is that they're very easy to apply. Okay. So in the common law, the party who seeks to recover a damage from the other party, the onus lies on him to prove his damage, okay, which is a subjective interpretation generally, which he has to prove to a judge that that's what he lost. When there's a penalty, no one has to prove anything. It's in the express contract. That's the amount per day. That's what you need to pay, okay? Of course, that means you need to manage time. So don't take on a contract where you can't complete it in the allocated time. It's not worth it. You'll spend all that time working weekends and overtime, spending all that extra money. You finally get to the end, you're a few days late, they apply the penalty, they'll wipe out all your margin on the job. Okay. So, yes, express contracts bring on risks. You need to know what they are and you need to manage them. Okay. And attendees, I hope that was of useful information this morning. I did have to crack on with it, given that we only had half an hour, but I hope you find it useful, and I hope you take my advice not to contract without an express contract. During the week starting the 17th of August, I'll be presenting a further session, of course, also of enormous relevance in today's times. My client hasn't paid me, what now? And of course, in that session, we will be talking about express contracts and not, okay? And what options are available to you, how you should set it up in your contract to deal with non-payment, and what to do when you don't get paid. But let me not get your hopes up too high. There's no golden formula to getting someone to pay that flatly refuses to pay you. If you have an express contract with specific terms, it is much easier. Okay, thank you everyone for joining me this morning, and I wish you all a great day and a further week ahead, and stay safe.